Start. Per contra, Shri Akhilesh Pratap Singh, Learned Counsel for the respondents, has submitted that since there is a statutory bar to approach the appellate tribunal within a maximum period of 120 days, so the petitioner must approach the appellate court within time so prescribed. If the petitioner has not approached the appellate tribunal within time so prescribed, the appellate tribunal has rightly dismissed the appeal of the petitioner on the ground of limitation. He has referred section 29 within bracket 2 of the Limitation Act 1963, which categorically provides that where any special or local law prescribes for any suit, appeal or application a period of limitation different from the period prescribed by the schedule. The provisions of section 3 of the Limitation Act categorically provides about the bar of the limitation. Therefore, in the light of section 29 within bracket 2 of the Limitation Act, the appeal of the petitioner has been rightly rejected by the appellate tribunal on the ground of limitation. On a plain reading of the aforesaid provision, it is clear as crystal that this court, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the period of 60 days from the date of communication of the decision or order of the appellate tribunal to him, may allow the same to be filed within a further period not exceeding 60 days. It is quite clear that this court has the jurisdiction to condone the delay, but a limitation has been fixed by the legislature, that is 60 days. Chhattisgarh State Electricity Board versus Central Electricity Regulatory Commission and others 2010 5 SCC 23. The issue that arose before this court was whether Section 5 of the Limitation Act can be invoked for allowing the aggrieved person to file an appeal under Section 125 of the Act after more than 120 days from the date of communication of the decision of the tribunal. It adverted to the anatomy of Section 125 and the Appellate Tribunal for Electricity Procedure, Form, Fee and Record of Proceedings Rules 2007 and opined thus. Section 125 lays down that any person aggrieved by any decision or order of the tribunal can file an appeal to this court within 60 days from the date of communication of the decision or order of the tribunal. Proviso to Section 125 empowers this court to entertain an appeal filed within a period of 60 days if it is satisfied that there was sufficient cause for not filing appeal within the initial period of 60 days. This shows that the period of limitation prescribed for filing appeals under sections 111 within bracket 2 and 125 is substantially different from the period prescribed under the Limitation Act for filing suits, etc. The use of the expression within a further period of not exceeding 60 days in proviso to Section 125 makes it clear that the outer limit for filing an appeal is 120 days. There is no provision in the Act under which this court can entertain an appeal filed against the decision or order of the tribunal after more than 120 days. The two-judge bench placed reliance on Singh Enterprises versus CCE Jamshedpur and others 2008 3 SCC 70 and came to hold that Section 5 of the Limitation Act cannot be invoked by this court for maintaining an appeal filed against the decision or order of the tribunal beyond the period of 120 days in view of the prescription under Section 125 of the Act and the proviso appended thereto. In that context, the court held any interpretation of Section 125 of the Electricity Act which may attract applicability of Section 5 of the Limitation Act read with Section 29 within bracket 2 thereof will defeat the object of the legislation, namely, to provide special limitation for filing an appeal against the decision or order of the tribunal, and proviso to Section 125 will become nugatory. After so stating, as we find, the court adverted to the concept of communication and eventually opined, the issue deserves to be considered from another angle. As mentioned above, Rule 94 within bracket 2 requires that when the order is reserved, the date of pronouncement shall be notified in the cause list, and that shall be a valid notice of pronouncement of the order. The counsel appearing for the parties are supposed to take cognizance of the cause list in which the case is shown for pronouncement. If title of the case and name of the counsel is printed in the cause list, the same will be deemed as a notice regarding pronouncement of order. Once the order is pronounced after being shown in the cause list with the title of the case and the name of the counsel, the same will be deemed to have been communicated to the parties, and they can obtain copy through email or by filing an application for certified copy. The eventual conclusion that was arrived at by the court was that there is no escape from the conclusion that the appeal in the said case had been filed for more than 120 days from the date of communication of the tribunal's order, and therefore as such the same could not be entertained. On being confronted as to whether, while rejecting the appeal of the petitioner, the judgment of the apex court in recognizance for extension of limitation case supra, which came on 10/1/2022, has been considered by the appellate tribunal or not, Sri Singh has submitted that though the petitioner had taken a specific ground in his appeal, but citing other similar judgments, the appellate tribunal does not find it proper to return any specific findings thereon. However, the said judgment has been indirectly considered by the appellate tribunal. On being further confronted on the point that before the division bench of this court, the specific information was provided on 4/6/2021 supra to the effect that no appellate tribunal is functional at Lucknow at that point of time, Sri Singh has submitted that though he was counsel in that case before the division bench of this court and has provided the information to the court on the basis of instructions so received, but some alternative arrangement was going on at Kanpur.